Hey, good morning, everyone in family law. Let's go over Chapter 9, jurisdiction. It's a short chapter, very important, and it does come up occasionally in a family law practice for us attorneys and paralegals that do family law. It's an important first step in determining whether or not we can do the case here in Massachusetts or whether it has to be brought into some other forum in some other state. So to start with, what is jurisdiction? This overlaps very significantly with the litigation class and the intro law class. We often talk about jurisdiction, the power of a court to adjudicate a dispute between litigants. And that's all it is power. Just think of any kind of movie you ever watch. People fight, say, you're out of your jurisdiction, I have jurisdiction here. That's the argument. And sometimes multiple courts might have jurisdiction, and other times it'll be exclusive to one court or one state. So let's start off right away with subject matter. There's two kinds of jurisdictions in every case: subject matter, and then there's personal. Subject matter is, does the court hear that kind of case? Now, I don't know about all states, but we have to, this course isn't trying to be taught based upon Massachusetts alone, but I use Massachusetts as an example. In Massachusetts, we have exclusive jurisdiction to hear divorce matters in the probate and family court, a court specially designed to handle those kinds of matters. That wasn't always the case. Prior to 1984, before I was practicing law, you could actually do a divorce case in the Superior Court. They had concurrent jurisdiction. Two or more courts could hear that kind of case. Just like to this day, the initial application of restraining order can be heard in the probate and family court, can be heard in the juvenile court, the district court, superior court, can be heard in many different courts because there's concurrent jurisdiction to hear those kinds of cases. Well, not anymore when it comes to a divorce. To seek a divorce, you have to go to the probate and family court. No other court can do it. So you can say, well, geez, my future ex-spouse and I, we both live in Gardner. We're getting along, but we've decided to end the marriage. Boy, it would be so convenient if we could just go file down into the Gardner District Court. We have an agreement. It's called that's the next chapter, the 1A. It's a straightforward joint petition for a divorce. Why can't we just go to the Gardner District Court? Because the Gardner District Court can never hear a divorce case. It just doesn't have the power or the authority to do it. It doesn't have subject matter jurisdiction. The bigger question is over personal jurisdiction. Do we have power over, and we don't care about the plaintiff, the party that brings the petition. The court clearly has jurisdiction personally over them because they filed their petition in the court. They're subjecting themselves to the court's power, but it's about the defendant. And this doesn't come up all that often, but it comes up enough that you need to know about this. You get somebody comes in the office, says, I want to get a divorce from my spouse. And the first question you have to start asking, when did you last live together? Because if they say, well, we last lived together here in Gardner. And when did the things break down? Well, it happened here a couple months ago or a year ago, or it's been ongoing for quite some time. And we've always lived in Gardner as a married couple. Easy. Not only do we have subject matter jurisdiction in the probate and family court in Worcester County, because that's what Gardner's part of, but we also have personal jurisdiction over the defendant because they last resided as a married couple right here in Worcester County in Massachusetts. And that's where the marriage broke down. Well, that's nice which is a run-of-the-mill case, often happens that way. What becomes more difficult is what happens if the spouses lived together last in Worcester and things fell apart maybe 3 years ago, and husband moved to Connecticut, has been living down in Connecticut. Wife wants to file for divorce here in Worcester County because that's where she resides, but can we get the court to make an adjudication against the defendant husband who now lives in Connecticut? In that scenario, we probably do. We have to do something called personal jurisdiction analysis. So one of the things that we have to determine is, does the state have a long-arm statute? I think every state in the union has a long-arm statute. Massachusetts certainly does. And what a long-arm statute is saying that we can reach beyond the borders of our state and subject a defendant to our court's judgment. And usually it's required that they have to have enough minimum contacts with the state, especially related to the nature of the cause of action that's being brought to court, to make it fundamentally fair to drag them into justice for our body. So the couple was married in Worcester County maybe 10 years ago. They had a marriage that lasted 7 years, and they lived together in Worcester County for 7 years. It fell apart. Husband had new opportunities, or spouse had new opportunities, went down to Connecticut. He's been living in Connecticut ever since. Can we file for divorce in Worcester County? Well, the short answer is yes, because the plaintiff has been residing in Massachusetts for over a year, because that's part of the analysis. And the second is the couple was last married and living together in Massachusetts, and the cause of the breakdown of the marriage, whether it's just irretrievable breakdown or one of the fall grounds, happened in Massachusetts. And now we have not only subject matter jurisdiction, but we also have personal jurisdiction over the defendant because they were here during the course and scope of the marriage for a significant number of years, and the events leading to the causal determination of the marital relationship happened in here in Massachusetts. What becomes more difficult, and this happened in my own office back many years ago when I was practicing, I had a woman come in. She goes, I want to file for divorce from my husband. She's been here for about 3 months because her parents live here in Massachusetts. She spent some time when she was a young person here in Massachusetts, but in the past 20 years, she was living in Kentucky. She gets married. Thank goodness there were no kids, because that would have definitely made it much more complicated. So she's married. She's in Kentucky. She lived in Kentucky for a 15-year marriage out in Kentucky. Things fall apart. And like a lot of things, when people's marriages fall apart, they sometimes go back to live with siblings and friends and family. And so she comes back to Massachusetts. Hasn't been here in 20 years. And now she wants to file a divorce in Massachusetts. The court has subject matter jurisdiction over the type of case she's trying to pursue. But the real question is can I get a divorce here in Massachusetts? She's been here for 3 months. They never resided as a married couple in Massachusetts, and the husband has no ties to the state of Massachusetts. Well, if she's only been here for 3 months, I can't, because there's a residency requirement that if the marriage cause of breakdown didn't happen as an event in Massachusetts, then it requires a plaintiff to live there for 1 year. So she couldn't file a Mass. Does that mean she can't get a divorce? No, she can, but she probably has to go back to Kentucky to get it. Now, what if she was here for 18 months? She finally decides, after writing letters and talking with her spouse back in Kentucky, it's not going to be reconcilable. They want a divorce. He doesn't want to come to Massachusetts, doesn't want anything to do with it. Can she get a Massachusetts divorce? Well, we won't have personal jurisdiction over the defendant's spouse in Kentucky. He doesn't have any minimum ties with the state. Let's assume he never visited it ever. We can't exercise our long-arm statute against the defendant to get an award of any kind of alimony, marital support, or division of marital assets. But can we get our client the divorce to legally end the marriage? Yes, we can, because the plaintiff has lived in the state for a year, and that gives the court power to have personal jurisdiction not over the defendant, but over the concept of the legal identity of marriage. I know that sounds really wordy and complicated, but basically I can get the plaintiff a divorce. I just can't get any order against the defendant regarding alimony, division of marital asset, or support. It's just going to be the ending of the legal marriage. Where it becomes really complicated is, let's go back to my scenario. Let's assume this person from Kentucky, they get married in Kentucky, the marriage breaks down in Kentucky, but they have 3 kids. Mom comes over here to Massachusetts with the 3 kids, and they've been living here for 2 years. Now she wants to file for divorce in Massachusetts. Can she? Well, yes, she can. But again, I don't know if I can get any order on the division of marital assets or spousal support. But a bigger question comes up, can I get a court order regarding child custody? Well, the kids are living with her, but did she get consent from the other spouse, the other parent, to remove them from Kentucky? She might actually be, in theory, exposing herself to charges of parental abduction. And that's a really big issue. But let's assume, dad just didn't have any interest in the kids in terms of being, a really active father. Now you'd have to argue to the court that by necessity they should exercise jurisdiction over the children, both for the custodial order but also for the child support. Someone's coming in the house here, so the dogs are barking. I apologize. So what they do is they would have to do analysis to say, is it justified that the current parent with the children here in Massachusetts did so legally? Did they basically violate the child abduction law, parental abduction law? And secondly, then they have to do analysis that, is it fundamentally just to order child custody orders in the state of Massachusetts, even though dad or the other spouse has not been in the state at all? And they certainly need to be given notice of the action, but can we order them to pay money even though they, by the state of Massachusetts, even though they've never been in the state of Massachusetts. Usually there is a connection that if the court does decide to exercise jurisdiction over the children in terms of custody and child support, the court does have the power to issue that kind of judgment against the defendant, even though they're living over in Kentucky, and the order could be enforced in the state of Kentucky, even though issued from Massachusetts. We know that from the Privileges and Immunity Clause in Massachusetts. Now, if your head hasn't spun completely off your shoulders because you're saying, what the hell did he just say? The point is, it's not that easy when you have the couple seeking a divorce and only one of them residing in Massachusetts. If they resided in Massachusetts, even for a minute, I should say that, for a short period of time, and the marriage broke down here in Massachusetts, they've only been here for a few months, one party leaves the state because they break it up, the other party stays here and seeks a divorce. Does the court have jurisdiction? Yes, because they were in Massachusetts as a married couple, and the marriage just broke down in Massachusetts. But the other scenario makes it very complicated. They weren't married in Massachusetts. They didn't reside in Massachusetts as a married couple. And one spouse remains in another state, Florida, Kentucky, Virginia. The spouse seeking a divorce has moved to Massachusetts. They need to be here for at least 1 year before they file to establish residency. But then there's real issues about whether or not the court should exercise jurisdiction over the minor children if they've come up with that spouse to Massachusetts, because you're not supposed to leave the state of where the parents have been. Think about it. Mom and dad are living in Virginia. They have 3 kids. There's no legal authority for either mom or dad to leave the states with those kids without the other person's consent. Sometimes it could be implied to the nature of the facts that surround the situation. But boy, if I knew somebody that was leaving Massachusetts, for example, and they're saying, hey, I'm leaving with my kids, I'm moving back down to with my family down in Connecticut, and I'll say, well, does your spouse consent to that? They said, well, yeah, pretty much. I said, well, can we get an email from them saying it's okay, you live down there, and you're going to maybe get some kind of a tentative, which is the next chapter, maybe a temporary order about how visitation and custody situations will work, because I'm fearful someone's going to call the police and try to get an award out for child abduction by one of the custodial parents. Apparently, I locked the front door, and my spouse is trying to get in, so I am going to open the door. Sorry about that. So this jurisdiction analysis comes up in every single case. It's not as easy as it sounds. In fact, there's books and form books and practice manuals on how to determine jurisdiction and powers of the court in probate and family matters like this. It's a challenge, and it does come up not that often, but often enough that the first thing you're going to ask your client in the interview is, where do you live? Where did you live last as a married couple? And did the breakdown of the marriage happen here in the state of Massachusetts? Usually those answers are all yes, but sometimes they're not. And then you have to be very cautious, because you don't want to file in Massachusetts and spend money and time the attorney's going to charge, and it's pretty much malpractice if you find that you filed in the wrong court. Sometimes you have to send that client back to the home state where they were last living as a married couple and where the cause of action developed. And the answer is not always crystal clear, and that's why I can't give you a clear rubric on how you determine it in all situations. That's both with the division of marital property, spousal support. That's even a bigger issue. Where kids go, the court will often exercise jurisdiction over those kids if they have a nexus to the state previously or have been here for a period of time, and if we can determine that the other spouse has probably assented to those kids coming to the state. But boy, when things get bitter, I never gave consent. My wife or husband took off with the kids. That's parental abduction. Usually those charges dissolve. But they can be first brought initially, and that puts the person that did it sometimes a little bit behind the 8 ball in trying to seek custody in the long term. Terminate custody, initial custody determinations. I'll give you some of the model rules. Here's the things about when it comes to children. It says home state jurisdiction, where are the kids living last, comparing the relationship between the home state and significant connections where these kids are currently now trying to domicile, emergency jurisdiction you try to raise, and those are the last resort jurisdiction. Decisions need to be made on behalf of these kids. Mom's here in the state of Massachusetts, been here for a period of time. Dad's implicitly, if not overtly, giving consent to do so. This court needs to exercise jurisdiction because significant decisions need to be made on behalf of those children. That's what you can argue, but you might lose, and you might have to go back to that state where they last resided. Modification of jurisdiction. And once jurisdiction is established, it usually stays. You don't transfer it. So if you start the case out in Kentucky, you're not going to come up here in Massachusetts and say, well, Kentucky's been going terrible. I want to have my case now heard in Massachusetts. It's not going to happen. And the court sometimes will decline jurisdiction. Now you've wasted a lot of time and money in that kind of a case. Jurisdiction, and that's pretty much a chapter. It's one of my shorter videos, but jurisdiction is one of those things we take it on a case-by-case basis, and we do analysis, and there's always new learning and curveballs on whether or not you can exercise jurisdiction in a case. I don't do divorce law anymore, but I'll tell you, that's one of the first questions that always come up, because I sometimes don't even want to waste my client's money and time if I don't have a lot of experience in the fact scenario, dealing with basically a person who's recently moved here, and especially if there's children involved. I'll say, you might want to look at somebody who does a lot of family law, who can make that determination, because I'm going to be doing a lot of research and charging you a lot of money to do something I don't have a clear answer on over jurisdictional analysis. But someone who's lived here, the marriage broke down here, and even though the other spouse has moved out since, that's so much. I don't want to say it's an easy case, but it is for jurisdictional analysis. I'll leave you at that, and I'll start up the next chapter pretty soon. Maybe not today, but the next one is, what do we do in the initial divorce proceedings? And I'll just touch on it real quick, because I don't know when I'll get to that video. Is when a divorce starts, it's very important to get temporary orders. One of the warnings I always tell everyone, once temporary orders are established, who's going to have temporary custody, where people are going to temporarily possess the marital home if there is one, and things of that nature. We tend to keep temporary orders and turn them into permanent if they're working fairly well, because we don't want disruption for kids in their lives beyond what's necessary. So I always warn people, don't get too comfortable with the concept of, it's only a temporary order. Because, well, yeah, if you let the other party have temporary primary custody of the kids, and we eventually get to a full-blown divorce, months or maybe years down the road, and the situation is largely working and the kids are doing well, we don't want to disrupt that. So I always warn people about agreeing to temporary orders unless that's something they could potentially live with as more permanent down the road. Be well, folks.